Speaker, sir.
Order. Questions for oral answer. Please proceed.
Mr. Speaker, may I seek your permission for questions 1 to 20 to be answered by the ministerial statement by Defence Minister later?
Please proceed. Associate Professor Denogo.
Question 21, please.
Mr. Speaker, sir, may I have your permission to take questions 21 to 24 together?
Please proceed.
Mr. Speaker, members have raised several queries relating to the recent disciplinary action against an orthopedic doctor for not informing his patient on the side effect of a minor medical procedure and the potential impact on clinical practice in Singapore. I understand Mr. Murali Pillai has also filed a similar question on this issue, and I hope that my reply will address the queries raised by the member. First, let me briefly set out the background. Dr. Lim Lian An is an orthopedic surgeon. His patient complained that Dr. Lim had failed to advise her on the possible complications arising from an injection of a steroid and local anesthetic injection, also commonly known as H&L injection. Dr. Lim's statement of the patient was found to be, I repeat myself, Dr. Lim's treatment of the patient was found to be appropriate, but he did not advise nor document in the patient's medical records possible complications or the patient's consent. Dr. Lim, who was represented by lawyers at the Disciplinary Tribunal, or DT, pleaded guilty to a charge of professional misconduct under Section 53(1)(d) of the Medical Registration Act for failing to obtain informed consent from the patient before administering the H&L injection. Through his lawyers, Dr. Lim asked for the maximum fine of $100,000 in lieu of suspension, or if the DT decided that suspension was warranted, a 3-month suspension. The SMC had sought a suspension of 5 months. After considering the sentencing precedents and the facts and circumstances of the case, the DT agreed with Dr. Lim's counsel that the maximum fine of $100,000 would be an appropriate sentence. Both Dr. Lim and the SMC did not appeal the sentence. Members have asked how this case would affect the future practice of medicine with regard to informed consent and what constitutes material information. Members also asked if the penalty was commensurate with similar cases in the past and how MOH would reassure doctors that only egregious cases will attract heavy penalties. Overall, members were concerned about whether the decision will lead to defensive practices and increasing healthcare costs. Let me first set out the overall situation before discussing the specific matters in this case. From 2013 to 2018, the SMC convened complaint committees, or CCs, to investigate over 900 complaints, and in about 92% of these cases, the CCs were of the view that no formal inquiry by a DT was necessary. In those cases referred to the DT, the profession accepted the DT's findings and sentences in most of them. Only a few cases were questions raised. Now, let me deal with some questions which have arisen in respect to this case. First, on the issue of informed consent. It is wrong to infer the decision makes it mandatory for a doctor to lay out and get the consent of a patient for every possible side effect and potential complications of a drug or treatment. Dr. Lim admitted that he was guilty of failing to inform the patient of any risks and complications. He was not found guilty for failing to inform the patient of all possible complications that could arise from the H&L injection. Second, what is considered material information? Under the SMC Ethical Code and Ethical Guidelines, or ECEG, doctors are to disclose relevant and material information to their patients, while remote risks with minor consequences will generally be deemed immaterial and need not be disclosed. What the doctor needs to inform a patient about prior to a treatment or procedure continues to depend on the specific facts of the case, including the particular circumstances of the patient. However, what is considered material information was not the issue before the DT in Dr. Lim's case, and the DT did not apply the modified Montgomery test, as Dr. Lim considered that he had not informed the patient of any risks or complications at all. In determining the sentence, the DT considered cases submitted by both counsel involving similar misconduct, where the sentences range from fines from $5,000 to $10,000, with $10,000 being the maximum penalty allowed before the increase to $100,000 when the Medical Registration Act was last amended in 2010, to suspension orders from 3 to 12 months, or both fines and suspensions. Ultimately, the DT decided that the maximum fine of $100,000 requested by the Dr. Lim's lawyer will be the appropriate sentence. There can be questions as to whether this was too high a fine and why the SMC was asking for a 5-month suspension. There has been considerable concern in the medical profession about the maximum fine having been imposed, and that at one point suspension was even considered. The concerns are understandable when considering the facts and circumstances of this case. Many fair-minded doctors would think that the penalty imposed was harsh. The appointment of a sentencing guidelines committee on 1st January 2019 will therefore help in ensuring consistency and fairness in the sentences method, and improve transparency and rigor in the disciplinary process. Mr. Speaker, the Ministry understands and acknowledges the concern of this decision, including the penalty, has caused to the medical profession. There has been feedback on the considerable confusion amongst medical practitioners on the requirements on informed consent and material information, and how the modified Montgomery test and the ECEG should apply. We want to take steps to reassure the profession and to clarify the position, as the Ministry of Health does not want the profession to go down the path of defensive medicine. We acknowledge that the profession needs assurance on what the legal position is and what the procedures, punishments are when the disciplinary proceedings are undertaken. We will need to discuss the issues with the profession in the context of a broader review of the current rules, processes, and legal position to achieve the above outcome. Our medical disciplinary process is self-regulated. While the SMC administers the disciplinary process, the CCs and the DTs comprise substantially of senior doctors and make decisions independently of the SMC. In arriving at their decisions, the CCs and DTs also obtain the opinion of experts who are peers of respondent doctors. This protects both the public and ensures fairness to the doctors. This system works well only with the support of doctors, and only if doctors understand and participate fully in the system. My ministry will carefully consider what steps are necessary to maintain the trust between patients, doctors, SMC, and MOH.
Associate Professor Denugo.
Thank you, SMS. The disciplinary tribunal says that the doctors don't have to disclose all side effects. But you've seen that in this case for the H&L injection, they listed out A to G, the side effects that the Dr. Lim should have informed and noted in the case notes for the patient. So it seems as though that although they say that the DT says that the doctor doesn't have to give all side effects, to list out all side effects to the patient, yet at the same time the charge is precisely that he had failed to list out all the side effects and that he should have done so. I mean, I could read out A to G, but it would be very long, and that's precisely the point, because it is a very long list, and the consultation will drag on very long for the doctor. So the question is for MOH, when you say material information is all that is needed, how? A to F, A to E, C to F, how many? It will be material information. And would, let's say, if the doctor informs the patient from A to E and leaves out F, but if the patient gets F as a side effect, would then the doctor be liable? Thank you.
I'd like to thank the member for the clarification. I'd like to reiterate that there is no need to list all the complications for a particular procedure. And what's important is that the doctor needs to inform the patient's complications or side effects that are relevant to the patient. In the grounds of the decisions by the disciplinary tribunal in this case, I note that there were 6 possible complications that were listed from A to F. But I'd like to reassure members of the House as well as the medical profession that these are just examples of some of the possible complications that Dr. Lim could have told the patient. But in this case, it is not a matter of whether sufficient complications or side effects have been counseled, but rather it's a case whereby Dr. Lim has failed to even inform the patient of any possible side effects.
Dr. Lim Wee Kiat.
Thank you, Mr. Speaker. I'd like to declare my interest as a practicing ophthalmologist. I think the medical fraternity currently has rallied, including with the public coming in, to raise a petition against this whole issue now. I think even for the public, they felt that this $100,000 fine is a little bit too excessive. Although, yes, I agree with SMS that it is self-regulatory, but self-regulatory doesn't mean that there's no regulatory. MOH should still have an oversight over SMC. And currently, my next question is, of course, what is MOH position, and will this current 100,000 fine be be reviewed again, rather than to leave it as it is? Because if you leave it as it is, then the medical fraternity will just say that there's no change in everything else, which means that we still could be fined $100,000 if we administer a simple procedure, and just we miss out one side effects, we can be fined. Thank you.
I'd like to thank Dr. Lim for the supplementary question, as well as to highlight the concern of the medical fraternity regarding this case. In particular to this case, we note that Dr. Lim's lawyer had actually requested either a $100,000 fine in lieu of suspension, or if the DT decided on a suspension, a period of 3 months. And of course, this is based on past precedents, as noted by both SMC as well as the defendant's counsel. While the DT could have ordered an alternative sentence, they decided to impose the maximum fine of $100,000 as proposed by Dr. Lim's lawyer, and not to impose a suspension instead. But we acknowledge the concerns raised by the medical community, and together with the Ministry of Law, we have assisted the SMC in appointing a sentencing guidelines committee on the 1st of January 2019, as I've alluded in my reply, so that we could assist the DTs and legal counsels in setting appropriate sentences going forward.
Mr. Murali-Pillay.
Mr. Speaker, sir, I thank the Honourable Senior Minister of State for his comprehensive explanation. My question revolves around the fact that in the recent past, I see that doctors were somehow disquieted by SMC rulings. Given that the medical profession is meant to be self-regulating, as mentioned by the Honourable Senior Minister of State, how do we address the gap between what is understood by the medical profession on one hand and the SMC rulings meted out by senior doctors. And in that regard, I note that there's sentencing guidelines that could be issued. What other steps can be taken to address this gap? Thank you.
I'd like to thank the member for the supplementary questions. Indeed, our medical discipline process is self-regulated. While SMC administers the disciplinary process, the CCs and the DTs, comprised substantially of senior doctors, make the decision independently of the SMC. So far, based on the statistics that I've given in my reply, majority of DT findings and sentences were accepted by the medical profession, and only a small number of cases attract some questions with regards to the decision. But based on these statistics, we can see that actually the self-regulatory processes are working very well. But I do understand there are some concerns with regards to informed consent as well as material information. And we will engage the medical community to clarify some of these doubts that they may have.
Dr. Lim Wee Kiak.
Thank you, Speaker, for giving me a chance to seek clarification. I would just like to ask the SMS again as to, in the past there has been precedents whereby DT has thrown out certain cases, but in the end, upon appealing to the ministers, the DT has to reopen the case again. In this case now, it's direct opposite, which means that DT has already decided whether currently now, since there's a petition from both the public as well as from the medical fraternity to the ministry, will the minister now consider reopening this case again? Yeah.
Thank the member for the supplementary question. This case has been decided at the DT and has been accepted by both the defendant as well as SMC, and therefore there will be no need to reopen this case. But having said that, we will continue to look at some of the concerns of the medical profession, and in fact we'll be engaging the 3 professional bodies of the medical profession to see how we can address some of these concerns, and at the same time, if necessary, we will review the disciplinary processes in the form of amending the Medical Registration Act, and if necessary, even amending the law moving forward.
Mr. Desmond Chu.
I thank the Minister for his clarification. I'd like to ask, while we have retained the Bolam test for the diagnosis and treatment, that has provided clarity, but a significant issue is the modified Montgomery test, and that has created a lot of confusion on the ground. Would the ministry then consider having it into the statute so that it makes things a lot clearer? And what is his view on the implications of clinical practice till the day we get clarity on this test? Thank you.
I'd like to thank the member for the very pertinent clarification. But to put things in perspective, the modified Montgomery test was introduced in the Court of Appeal decision recently, and not by Ministry of Health or the SMC. And prior to the Court of Appeal's decision in Hitchcock's case in 2017, it was settled law in Singapore that the assessment of whether a doctor has met the requisite standard of care in all aspects of his interaction with the patient should be made with reference to the practices and opinions of a responsible body of medical practitioners, although such practices and opinions must be logically defensible. And this test, like what Mr. Desmond Chu has mentioned, is also known as the Bolam-Bolito test. In May 2017, the Court of Appeal in Hitchcock decided to move towards a somewhat more patient-centric approach when assessing the doctor's duty to advise, as the court opined that the patient has autonomy over whether to proceed with a treatment and requires full information to make this decision. I'm clearly aware of the concerns of many medical professionals on the modified Montgomery test. I've personally received many feedback from fellow medical practitioners, especially on the requirement on informed consent and material information, and how these new tests should be applied. There are also feedback from the medical community that this may lead to defensive medicine and escalation of healthcare costs. MOH is aware and understands the apprehension and the confusion and uncertainty on the ground, and MOH and SMC are studying the ruling and will consult the profession on what should be the appropriate practice in Singapore moving forward.
Professor Fatima Latif.
Thank you, Speaker. Can I ask the Minister, with the changeover to the modified Montgomery test and also the taking the Chi Hikok case as an example, which of course has its pros and cons as well. Moving forwards, because we practice in a restructured hospital where there are lots and lots of junior doctors and personnel in training who are performing procedures almost every day and taking consent. So perhaps the Ministry of Health, will you be able to come up with some kind of standardized guidelines for doctors in practice as well as for specialists perhaps, and also perhaps to do some focus group discussions, not only with the senior representatives but also with the junior level of doctors, because they are the ones where we need to allay their anxieties, and they are the ones running the clinics, whether through direct supervision or indirect supervision by seniors and consultants. They are the ones who are running our clinics and the hospitals in restructured setting most of these days.
I'd like to thank Professor Fatima Latif for the suggestion. Indeed, I think we need to continue to provide education, to medical profession with regards to proper documentation as well as consent taking. And in fact, it is important that the medical professionals properly document the management of patients under their care, because properly kept medical records form the basis of good management of the patient and of sound communications pertaining to the care of the patient. In fact, anecdotally, it seems that many complaints by patients could have been avoided if their doctors had communicated with them better. So one good example is in the Hitchcock case where having proper documentation can actually even protect the doctor against unmeritorious complaints.